there, welcome back to All Up in Your Business. I'm attorney Aiden Durham with 180 Law Co. in Colorado, and today I'm going to tell you about 5 pretty common mistakes that I see folks making with their trademark applications and what you can do to avoid those mistakes. Actually, you know what, I'm going to throw in a little bonus 6th mistake that I just thought of, so make sure you watch until the end to see that one too. Before we get into all that though, keep in mind I am a lawyer, but I am not your lawyer. The stuff that I talk about in this video isn't a substitute for actual legal advice. If you need help with any legal situation, you should consult with a lawyer who's licensed in your state. Oh, and if you want to learn even more about trademarks and trademark stuff, I've got a free guide for you that goes into a lot of detail about trademarks and trademark registration. You can get that in the link down in the description. Again, that is a free trademark guide, link in the description for that. All right, so as a trademark lawyer, of course, a lot of what I do is helping clients with their trademark applications. I prepare a lot of trademark applications and file them and prosecute them and help get them to the end goal of being registered. But in addition to that, I also do a lot of fixing of applications, or attempting to fix as much as we can, because I have people who come to me after they have tried to maybe submit an application on their own, or they used some kind of an online filing service or something, and something was done not correctly. So, you know, a little too late sometimes, but they will come to me or another lawyer to try to fix those things. And so I see a lot of the mistakes that people make. One of the biggest ones, my number one mistake that I see people making, is not doing enough research. Specifically, not doing a good enough clearance search for their trademark before they move on to the application and actually trying to register it with the USPTO. I did a video recently talking about a few tips for doing a clearance search on your own and a few free resources for it. You can check that out. I'll put a link to that down in the description. But the very first thing that I do when I have a new trademark client, the very first step in my process is doing a comprehensive search of the USPTO database, as well as kind of common law internet usage too. And we want to search for, of course, identical matches, but also anything that might be confusingly similar to our trademark. I want to know, before I even go on to thinking about the application, I want to know, do we have even a decent shot at getting this trademark registered, or is it going to be dead in the water as soon as we submit it? It's not always, there's almost never a clear answer of, yep, we're totally in the clear, no issues. There is sometimes a clear no, like no, we're definitely not going to get it barring any unforeseen circumstances. Often it's going to be somewhere in the middle of, you know, there's some risk to it, but we could get it. We might have to fight for it a little bit, that kind of thing. So if you're doing it yourself, again, check that last video that I did. Ideally, the best thing you can do is to work with a trademark lawyer though, to have that search done. The second mistake I see people making a lot is waiting too long to file their trademark applications. Maybe you are just starting a new business or rebranding or launching a new service or new product or something. Maybe you went to the lawyer, you had that trademark search done, you got an opinion letter back that said, hey, I don't think we're gonna have any issues. We should go ahead and file the application. You think, cool, let's go launch the business. Let's go do all the things. But ooh, I'm gonna put this trademark thing on the back burner. We can get to that later. That's sometimes okay. Sometimes though, it's a big mistake. Every day that you wait, the longer you wait to file an application, the greater the risk that somebody else is going to, in that time, file for a trademark that would be confusingly similar to yours. And since they filed it first, it would be processed first, and it could create an obstacle or a barrier to getting your trademark registered simply because somebody else filed before you got to. So as much as possible, it's best to file a trademark application, get that process started as soon as you can. I know for everybody, it's not always like an easy thing. I don't have all the money to put into it right now. Sometimes we have to wait, but if you can swing it, the sooner the better. don't wait. Mistake number 3 that I see a lot, mainly from folks who are filing applications on their own, is using the wrong goods and services descriptions on their application. So a little bit of background: when we're filing a trademark application, of course, we have to give information what the trademark is, but we also have to indicate the goods and or services with which we are going to use the trademark. So what are we selling? What are we providing under this trademark? We have to put that info on the application. And it's not always straightforward what our goods and services actually are. The goods and services are broken down into classes or categories, kind of. I think 45 different international classes of goods and services. And they're broken down, you know, like items, like services, and similar goods are going to be in usually the same class. But even within that, it's hard sometimes to figure out what exactly are we selling. A good example I saw one time, I think the person was a photographer, and they, you know, what their services should be something like photography services. But this person, you know, I kind of get the rationale behind it. They put their goods and services as like cameras and photos. They were selling photos, which that might be the case, but if you're selling a photo, that's different from providing photography services. And so it's often that differentiation that isn't going to be obvious to folks who aren't trademark lawyers or experienced with trademarks and trademark applications. There's also often issues with how broad or narrow we want these descriptions to be. There are goods and services descriptions that are super broad, like shirts, for example, or there are really narrow descriptions like tank tops or t-shirts. So we can be either really broad or we can be very narrow. Sometimes it's better to be narrow because we want to avoid conflict with another trademark. Sometimes it's better to be broad so we can have as far broad reaching of rights as possible. So another kind of along those same lines is not being as narrow or as broad as you should be with your goods and services descriptions too. And this, unfortunately, is one of those mistakes that we can't always go back and fix. We can, so let's say you started with a really broad goods and services description, we are permitted to narrow or get more specific with our goods and services, but it doesn't go the other. Ow, dang. I'm gonna bruise from that, jeez. But it doesn't go the other way. We can't broaden our goods and services. We can narrow, but we can't broaden. So if it's a situation where someone just put flat out the wrong goods and services, we usually can't fix that. We have to scrap the application and start from the beginning. Mistake number 4 has to do with use in commerce and the dates of first use, and not understanding exactly what this means. So when we are doing the goods and services on the application, listing all of that, we have to indicate a filing basis as well. The two most common are current use filing basis or an intent to use basis. Current use means we are currently actively using the trademark in commerce. We're selling our goods and services with the trademark attached to them, basically. Intent to use means we're not, but we have a bona fide intent to do so. And the mistake that I see really often coming from this is an applicant will say, yeah, I am currently using it in commerce, and they'll put a date of first use, but then in, asking more questions, really digging into it, turns out, nope, you're not actually using the trademark in commerce. A few things that don't constitute use of a trademark is like registering your LLC. Oh, I hear that so much. What's the date of first use? Oh, it's this date. That's the day that I formed my LLC. That's the day I registered the LLC. No. Registering an LLC, setting up an LLC or a corporation or any other kind of business entity, that in itself does not constitute valid use of a trademark in commerce. Same thing with getting a domain name. If you don't have a website there that's actually selling your stuff, just having the domain name does nothing. That doesn't mean use either. There's a lot of intricacies to what exactly use of a trademark means. The easiest, most kind of straightforward way to think about it is that you are actively promoting, marketing, selling your products or your services. That's it. And of course you're using the trademark in connection with those efforts and in the ordinary course of business. So you can't just like make a sale to your mom just to say that, oh yeah, I sold some products. That doesn't count. It has to be like real. You're actually using the trademark. You're putting it out there. Consumers are experiencing it in the marketplace in real life. So if you aren't sure about your date of first use, read into the application and stuff. They have, the USPTO has some resources kind of explaining that. Of course, even better, talk to a lawyer about it and have them help you figure out if you're actually using the trademark in commerce, because this is one of those mistakes that we can fix it usually, but it can be really bad. It can be really bad. Let's say you put the wrong date of first use on your application. The USPTO, they're not like automatically going to audit all of these forms. They're taking our word for it usually. If we say my date of first use was January 1st, 2023, they're going to take our word for it. But let's say a few years down the line, someone tries to challenge us on our trademark rights. Someone comes along and says, hey, we have priority because we were using it earlier than your date of first use. Now we're going to have to fight about who is using it first. We're going to have to now prove that date of first use. And if we can't prove that we were actually using the trademark in commerce on that date that we indicated, that could, really throw our position out the window. It could invalidate our registration. A lot of bad stuff can come from it. So making sure you're using the right filing basis and the correct date of first use is really important. And the last, the last of the 5, not including the bonus 6th mistake, but the last mistake is failing to meet deadlines, not monitoring deadlines. So the application, of course, we file that whenever we need to, but then the application is going to be assigned to an examining attorney, and the examining attorney is usually going to send us some documents, whether it's an office action or maybe a notice of allowance. There's going to be some part of the process usually where we're going to have to file some additional documentation with the USPTO. And there's usually going to be a deadline associated with that. With office actions, for example, we have to respond within 3 months. With a notice of allowance, I'm not going to get into the whole thing, but we have to respond to that one way or another within 6 months. And if we don't meet those deadlines, we could lose the application. It becomes abandoned. We're SOL. So make sure you are monitoring, make sure you put the right email address on your application. Make sure you are monitoring that email address for any correspondence from the USPTO. Check your spam folder just in case. Make sure you put any deadlines on your calendar. Don't forget about those deadlines. Okay, don't forget. And finally, my bonus number 6 tip has to do with like the online filing services like the LegalZooms and stuff. The tip really is don't use them. That's the tip. Don't use them. There is some, sometimes they can be helpful, but generally not. Like I said, a big part of my business is fixing trademark applications, and a lot of those that I have to fix come from LegalZoom or similar filing services. So I have firsthand experience at knowing that they don't always do it well or correctly. And a little fun fact to send you off with, a little fun fact. LegalZoom has a portfolio of trademark registrations themselves. Guess what? LegalZoom doesn't use LegalZoom to file their own trademark applications. Even LegalZoom works with a lawyer. I have trademark registrations too. Guess what? I've filed and prosecuted all of my own trademark registrations because I know that I trust myself and I'm doing a good job at it. It appears LegalZoom doesn't have enough faith in their own company that they don't even use their own company to file their trademark registration. So that's all. That's just, do with that what you will. That's all. Okay. If you learned a thing or two, go ahead and give me a thumbs up. And while you're at it, make sure you subscribe and share this video with all your friends, okay? And you can check that link down in the description for that free trademark guide that you can download as well, and some other free resources and info down there too. I know the use in commerce thing, probably sounded a bit confusing, because it is confusing and I glossed over a lot of it. If you're confused more, or if you want to kind of learn more about the filing basis and what use in commerce means, I've got another video where I can go into a lot more detail about it. You can check it out right there, and I'll meet you over there. Thank you so much for watching. I'm Aiden Durham, and I will see you next time.